we have a record attendance for today's program. So everyone is definitely excited to get back out there and get into your pools. Before we get into the program and I introduce who will be speaking today, I wanted to let everyone know that at the end of the luncheon, as normal, we will be giving away 4 $50 Amazon gift cards on behalf of, or maybe not Amazon, right, Jesus? It might be something else, but it'll be $50 and it will be on behalf of the sponsors of the sponsors Alliance Association Bank and Craftsman Commercial Playgrounds and Water Parks. Now, as a reminder, you do have to be present at the end of the meeting in order to get your gift card, so stick around. I want to just give a shout out to any new members that we have who are in attendance this morning. Welcome, welcome to our new members. And just very quickly, I want to see if we have any of our committee chairs on the line who might like to give a quick update on what's going on with your committee. I'll start with Awards and Recognition Gala. Janae, are you here? If you are, unmute yourself, please. All right, I don't think Janae's here, but I do know that that committee has an upcoming meeting. I believe it's on Thursday of this week. If anyone's interested in discussing the gala that will be next January, please do reach out to Janae or reach out to Jesus and he'll get you in touch with Janae. Golf tournament, Jesse and Janae. Jesse, are you with us? No. Okay. Well, the golf tournament has been postponed to October. And now that everyone's anxious to get out, we expect that everyone's going to be super into that golf tournament. So please, again, contact Jesus if you have any questions about the golf tournament. If you want to sponsor, if you're looking for any information, Jesus is the one to ask. Next CA Day, Lucy, are you online? I don't think she's here. Jesus, you want to talk about CA Day quickly?
Sure, real quick. CA Day is August 27th at the Norris Conference Center. Same place, same location as 2019. If you go to our website, the landing page is now online for sponsorships and exhibits. So please check that out. We won't open up registration for maybe about a month and a half. But certainly if you're a business partner out there looking to exhibit or sponsor, there's a certain number of opportunities. So please check out our website, caisa.org.
Great, thank you, Jesus. Commentara, Art.
The second quarter of 2021 has been published online, so I'm in quiescent mode now.
All right, thank you, Art. Education, Tom?
Yeah, hello, everybody. The Education Committee is planning our next board leadership development workshop for next month. You can look on the chapter's website for the exact details, but it'll be on a Saturday. We've experimented with having our classes on a weeknight and splitting it up into 2 components, but that doesn't seem to be the best way to do it. And so we've gone back to weekend classes, and I expect that that will be a virtual training. And I would encourage all of you who are interested to come and bring your questions, and we'll be glad to talk to you about it. And thanks for being here for today's program.
Thank you, Tom. Membership, Amaris, are you here? Not hearing Amaris. Jesus, you want to talk about membership?
Sure. We had a great event at the Chicken and Pickle on April 1st. There is a great video. Thank you, Javier Urias with Urias Media, one of our members at CCMC. Recorded some great testimonials from some of our key folks. And I'll post a link in the chat feature here so you can check out the YouTube video he put together for us. But certainly the membership committee has a couple things planned. One, we've discussed a new membership orientation. And also we're looking to get some folks together to really push our communication with existing and expired members. In addition to that, we're also looking to plan a few more in-person networking events in addition to our in-person education. So please, if you're looking to join that committee, get involved. Membership is a cornerstone of our chapter. So please reach out if you need any more information or are looking to join.
Looks like we have a question, Jesus. Lewis, you want to unmute yourself and ask your question? Nope, maybe he didn't mean to raise his hand. All right, sponsorship. We are still looking for our chair of the sponsorship committee. We have had some interest, but no one who has said for sure that they're willing to do it. It's a good amount of work, absolutely, but it's also gives you a great deal of exposure to the chapter. You get to know everybody. It's a really important job. So if anyone is interested on the line, please contact Jesus about that position. And then finally, we've got our TCAA legislative update. Paul.
Thanks, Leah. Good morning, everyone. So there's been a lot of movement at the Capitol this month concerning POA related bills. There were over 100 POA related bills that were filed. Now they're moving through the House and Senate committees. Many have already had hearings, while others are waiting to be heard. Some of the bills, such as the new religious display bill, the new chicken bill, and then bills related to discriminatory restrictions, those are getting a lot of attention and they appear to have a lot of support. So we're going to be closely following those. Once the committee hearings conclude and the smoke clears here, we will provide the chapter with further updates.
Great, thank you, Paul. All right, next on our agenda, before we get to the program, we are going to announce the winners of the Snowvid 21 drawing. Jesus, you wanted to, I think, circulate some of the photos that we did receive, and then we'll announce the winners.
There we go. Thank you, everyone who participated. So what we're going to do is I'm going to show some of the photos that were submitted, and then I will draw the names as a reminder. The way it worked, basically, the more photos you submitted, the more options, the more tickets you had in the bag. So we have some good ones here, and I'm going to flip through these. And this is Richard Gonzalez. You can see the snow's packed up high. That looks like a very nice little view there. Got super creative there. I think my wife has the same purse, actually. I know my daughters have the same bows there. This is Maya Smith, the CCMC. Just amazing photos. Quite a view. Leah, I think that's recognizable. You got to tell me what happened there.
That was a low point. I was sopping up water from a burst pipe in my parents' house.
Oh, well.
I hadn't washed my hair in probably 3 or 4 days.
Okay.
Let's go on ahead.
I think we're all there. Yeah, let's move on. Cassie with the kids and the dog. I think I tried a handstand like that a couple of years ago. It didn't work out so well. But this is Lucy. I was hoping she was on the call. I didn't know if the dog was scared or happy. That's her little pup there. And Elaine Valdez, the Pavona Place HOA. The snowman's seen better days, but nonetheless exciting. This is a really cool shot here with the water coming down the letters, hidden trails. Thank you, Tracy, for submitting those. Thank you to all who participated. Let me unshare my screen here. So what I'm gonna do, I'll do this real quick. So you know it's official. Bag. We're gonna draw the names and the first, I won't look. First winner, $100 gift card, Cassie Thompson, Patriot HOA Management. Congratulations, Cassie. I think you're here. There you are. I see ya. Thanks for submitting. Next up, this is exciting. Again, you can only win once. Right? There we go. Maya Smith, CCMC.
Yay.
Congratulations, Maya. Thanks for submitting. And we've got one more here. What do we got here? Lisa Frantangelo, Dominion HOA Management, or HOA. Lisa,
Congrats.
you're not here. I don't know. I don't see you. Thank you all, Maya, Lisa, Cassie, for submitting, participating. Thank you, everyone. It really helps to see your experience, and I think we all want to move past that event.
All right. Thank you, Jesus. Sorry, you want to say something?
We have some just some housekeeping items real quick. Oh, Leah, why don't you take on that? I'll let you have that.
Oh, only that during the course of the program, please put your questions in the chat, and Greg and Tom and Mark will be happy to answer any questions that you might have during the course of the program. And that's all I had as far as housekeeping, Jesus.
Yep, this course is approved for one CEU with CAMICB for you CMCAs out there. If you need a certificate, please contact me after the presentation and I can send that over to you.
All right, thank you. So without further ado, let's get into today's luncheon program, which is titled Reopening Pools and Common Areas, a Legal Discussion for Community Associations. I'm going to turn it over to Tom Newton to get into the program, but we've got presenters Gregory Cagle, partner with Cagle Pugh, Tom Newton, a shareholder with Allen Stein and Durbin PC, and Mark Sowell, the owner of Seven Wells Pool Management. Tom, go ahead, take it away.
Thank you, Leah, and thank you all who are attending for your interest in this program. We've got this divided up into 3 parts. I'm going to address things that you need to know about swimming pools in terms of liability that property owners associations may have. And so we'll discuss some of the standards by which courts judge cases involving injuries at property owners association facilities. And then we'll also discuss the swimming pool safety standards that are contained in the Texas Administrative Code that has a whole variety of requirements that your pool needs to comply with. I'm also going to talk to you about the doctrine of charitable immunity and volunteer immunity under Texas and federal law. And then finally, I'm going to give you my own thoughts on reopening your swimming pools and when and how you should do that. And then after I've finished those topics, Mr. Cagle is going to address his own opinions to you as to COVID practices, swimming pool reopening wise. And I can tell you that Mr. Cagle and I have discussed it, and it's probably not a surprise to you. You got 2 lawyers and 2 different opinions. So I'll let you know what I think about it, and then Greg will tell you what he thinks about it, and it'll give you plenty to think about. And then we have Mark from Seven Pools, I believe, or Seven Oaks Pools. That's going to help give us perspective of a pool professional as to things that you ought to consider. So first of all, Jesus, are you able to allow me to share my screen?
Yes, sir. Let me. Okay, you should now.
All right. So can you see the Texas legislature online? Is that what you're seeing?
Yes.
Okay, good. All right. So let's start off with some basics. If you want to know what the law says, you can look it up. And it's really easy to do. So I'm going to give you this basic tip that would apply to anything you want to do. This is the home page for the Texas legislature. You can look up bills and find out more about what's being proposed, or you can do additional searches. And the additional searches are, for instance, statutes. So if you just go to this page, you click on statutes, you have to make 3 choices. You have to select the code that you wish to review. A lot of times we look at the property code in our discussions about property owners associations. So that's a common place that you would want to go. And then you want to know, well, what are the rules about property owners associations? If you go to chapter 81, that's the old condo law. And then chapter 82 is a Uniform Condominium Act, which is a law that governs all condominium associations for which the declaration was recorded after January 1, 1994. And pursuant to the applicability provisions in this statute in 82.002, you'll see that there are certain subsections of Chapter 82 that do apply to condominium associations. So if you were looking up the law, that would be something you would want to know. So getting back to the property code, if you're not in a condo, you're going to want to look principally at either Chapter 202, which deals with construction and enforcement of restrictive covenants. So you just click on that link and then you can search it. And it's got all the laws about flags and everything else. They did move the political signs to the elections code, but most restrictions on the applicability of covenants can be found in Chapter 202 for all subdivisions. And then you go to Chapter 209, and that covers residential mandatory property owners associations. And that's really the body of law that property owners associations that are not condominiums are governed by. And it's got all the provisions that you've heard about with respect to things like management certificates, a statutory method of amending your declaration on 67%, and so forth. So that's a good statute to know. So now let's talk about swimming pools. So when a property owners association owns or has control over property, it's subject to the general rules applicable to premises liability. And so that's fundamental negligence law. So Texas categorizes land entrances in people who come onto your land in 3 categories. And the duty that's owed to them is dependent upon their category. You have trespassers. I don't think that needs much explanation. You know what a trespasser is. Then you have licensees. A licensee is someone who comes onto the property with bare permission, which can be revoked, like every time you go to a movie theater. That's a license to be present with the permission of the person in charge of the facilities. Or finally, you can be an invitee. And if you're an invitee, that means that there's some sort of a business relationship. You're open to the public. So when someone's on the property for a property owners association, they're going to be treated as an invitee. So let's look at the standards. If it's a trespasser, your duty is not to injure them intentionally or through gross negligence. So I'm sorry to tell you this, but no booby traps. That's not okay. That's injuring them intentionally or through gross negligence. But if they're a licensee, you're even greater duty. This is a copy of the Texas Supreme Court opinion in State Department of Public Highways and Public Transportation versus Payne, which was a suit that did not involve swimming pools, but it sets out what the law is with respect to licensees. And here's the duty. If someone's a licensee, you have to not enter them willfully, wantonly, or through gross negligence, just like the trespasser, but then they get added protections. And you have to use ordinary care to warn of a dangerous condition that's known to you and that's not known to them. So that takes us to the Texas Supreme Court case of Fort Brown Villas versus Gillenwater, which discusses the duty owed to a licensee, which is what your owner's going to be. So here's what the duty is under the law. The person who's been injured has to prevail, can prevail if they can prove these things, these 4 elements. Number one, they have to prove that there was a condition that was an unreasonable risk of harm. Okay, we could spend hours talking about what is an unreasonable versus reasonable risk of harm. But if it's something that's, you know, just not reasonable for people to be running, you shouldn't do it. And you're liable if you knew or should have known about it. Now, notice that that's different from the duty to licensees. For licensees, you have a duty to warn them of things that you know about. But for invitees, you have a duty to warn them about things that you should know about. So that's a duty to inspect, to look for hidden dangers and to fix them. So you have an unreasonable risk of harm, you knew or should have known about it, and then you failed to exercise ordinary care, which is going to be decided by a jury. And they're going to be instructed by a judge on what ordinary care means. And what it means basically what a reasonably prudent person would or would not do. So a jury is going to be the judge of that. So did the association do anything or fail to do anything that violated ordinary care? And then finally, you have to show that the failure approximately caused your injury. So that's what you need to know about premises liability. Your different standards apply to different people. Now, just to touch on this for a little bit, in the Fort Brown case, what happened was that this guy, Coy Gillenwater, he rented a condo. And then he went down to sit at the pool. And when he's lowered himself into the chair, the tip of his finger was severed because there was a broken weld on the pool chair. So he sued the association. And the case turned out to be favorable to the association because they didn't know or have any reason to know that the chair was defective. So if it's a hidden danger that you don't know or shouldn't know about, you're okay. Now, just another case I found when I was looking at premises liability law for property owners association is this Towers of Town Lake case out of Austin. It's a 2009 case. And this is an interesting case about how serious injury cases can become. So here's what happened. This lady, Miss Rouhani, is a dentist, and she went to her niece's birthday party. So she was just a guest of a resident, and she was sitting in this pool chair, and the kids were splashing her. So she was splashed with water from the pool. So she got up to get away from being splashed. She took 2 or 3 steps and slipped and fell. And the injury that she sustained was not a minor one. It fractured her elbow. For a dentist, that's a bad thing. She had to end up shutting down her practice, selling it off. And here's what the jury did. They found that the association's negligence caused this lady's injuries. They found for her $900,000 for future loss of earning capacity, $100,000 for past pain, $200,000 for future pain, 67 grand for lost earnings. Oh, another 100,000, why not, for impairment past, and 200 more for future. Let's give her $75,000 for future, $70,000 for future medical expenses. This is how much that accident wind up in being liability to that association. $1.6 million. When you have bad injury cases, as long as somebody can show an association is negligent, they failed to exercise ordinary care. There was a condition they knew or should have known that they didn't do anything about, failing to exercise ordinary care and causing damage, you're liable. Now, having said that, we'll switch for a moment to swimming pool safety standards. This is not in Texas statute. This is part of the Texas Administrative Code, which, by the way, you want to look at the Administrative Code, just go here to that same page I showed you and go to Administrative Code. Boom. What do you want? We are going to look at Title 25. And we're going to look at Part 1. And then when you look at Part 1, Chapter 265 is general standards. And subchapter L is public swimming pools. So when you look at the definitions, number 76 is categories of pools. Okay, so what applies to you in this administrative code depends on which category you fit in. Kind of like land entrance. You got to be put into a bucket, and there's 3 buckets. There's class A, B, and C. Y'all are all class C because it's operated by a property owners association. And so you need to look at this because it gives you all kinds of rules about instructions you have to have and all manner of things. So, and then it's got rules on the decks and just everything. We don't have time to go through that right now, but you need to have a professional swimming pool company like somebody like Mark that can help you wade through this because it can be difficult. Now I'm going to switch gears and we're going to talk about charitable immunity and organizational immunity. Back in the 1980s, there became a national movement to provide protection for volunteers to kind of help with President H.W. Bush's policy of 1,000 points of light. Let's have everybody pitch in and help out. And to make it something that people are willing to do, we're going to give them some protections. So there are both state and federal law that provide protection to property owners associations for their volunteers. So let's start with the federal law. That's 42 United States Code, Section 14503, which discusses limitations of liability for volunteers. So first of all, unless you fall in subsection B, C, or E, okay, so there are exceptions. And we'll go to the exceptions in a minute. But if those exceptions don't apply, no volunteer is liable for harm or act that they committed as long as they were acting within the scope of their duties. That if they were required to be, they were licensed. The harm was not intentional, was not willful, the result of misconduct or gross negligence or reckless. So it's got to be an innocent mistake. And then it doesn't apply to basically accidents involving vehicles and watercraft and those kinds of things. For which you have to have a license to operate and you have to have insurance. So the exceptions are pilots that fly for the public benefit. We don't need to talk about that. Nothing, by the way, in this section is construed against to prohibit the association basically from going after the volunteer. and D. This is not organizational liability. This is individual liability. And so there are exceptions. And in the interest of time, I won't run through all of them, but I want you to know they're there. But that law is substantial protection for property owners associations because they are insulated from liability as long as they don't do something that they know is wrong. Now, Texas has its own law, and that's the Charitable Immunity and Liability Act of 1987, which passed around the same time as the Federal Volunteer Act. It's located in Chapter 84 of the Texas Civil Practice and Remedies Code. Okay, so I'm jumping codes on you. So let's just go back for a second. Let's go back to, okay, can I get back to that? We'll just go to the way I normally do. All right. So you want to look at the Civil Practice and Remedies Code? Same deal. Pick the statute you want. Civil Practice and Remedies Code. Here it is. You won't be expected to know this off the top of your head, but it's in Chapter 84. Charitable immunity and liability. And then it's got several sections to it. We'll take a peek at some of it. So the legislature finds that robust, active, bona fide, and well-supported charitable organizations are needed. And willingness of volunteers to participate is deterred. They're not willing to do it, but because of personal liability. And so what we're going to do, it's the purpose of this act to reduce liability exposure. So you got to look at charitable organization first. And it's not something that's intuitive, but property owners associations are included. Right there. They're included as charitable organizations. Now, let's look a little further. Here's the volunteer liability, which is the analog to the state Volunteer Liability Act. And it says, unless subsection D or 84.007 applies, a volunteer is immune from liability. You know what immune means? It means you can't get it. You have no liability for any act or omission resulting in death, injury, or death, damage, or injury if you were acting in the course and scope of your employment. So let's look at D and 007 to see what the exceptions are. D, you are liable for things that you do in connection with operation of motor-driven equipment, okay? So then organizational liability is capped. It's not an immunity, it's a cap. And the cap is $500,000 for bodily injury, or $1 million per occurrence for bodily injury, or $100,000 for property damage. Okay, so that's the cap of liability. But look at 84.007. First of all, it doesn't apply to intentional or willfully negligent acts. It doesn't apply to duties owed to the association itself. And then it talks about healthcare providers. But here's the hook. And this is where you need to talk to folks like our insurance sponsors, because you have to have that much insurance coverage. The same amount of the liability that the law says you can have, you got to first be insured for it. If you do, your liability is capped. So property owners associations have concerns about premises liability law because you could be liable if you're found to have been negligent. But your liability can be capped. For volunteers, you can be immune, and the organizational liability is capped at what your insurance has. So there are protections. Now I'm going to talk to you about COVID and reopening the swimming pool and then turn it over to Mr. Cagle. As I said, we have different opinions about it. I'm still hearing from public health officials at the federal level that it's too early to let our guard down, that maybe in a few months, things will be a lot safer, but not right now. And therefore, my advice is do not reopen your common area facilities that lend themselves to a lack of social distancing. Playgrounds, no. Swimming pools, nope. Clubhouses, Basketball courts, no. Walking trails, okay. Tennis courts, yeah, you can do that safely. Soccer fields, I ain't so sure about that. That's kind of like basketball. I'd probably say no to that too. I'm being cautious on behalf of my clients, make sure that they're not, if you get sued, first of all, even if these laws protect you, you're going to have to turn it over to your insurance carrier if you're not going to avoid your coverage by failure to report the claim. They're going to take it over. And most civil cases end up in a settlement, a payout of some amount of money if there's a legitimate injury. And so your association may get sued. And I'll tell you right now, as a lawyer who represents associations and occasionally gets hired by insurance companies to defend them, they look at the bottom line. If it was going to cost them $100,000 to settle and $100,000 to try the lawsuit and $10,000 to settle it, they'll settle it in a heartbeat to save $90,000. The consequence, of course, will be you get a bump in your premiums. So even if you've got protections, you don't want to have a claim. And of course, you don't want anybody to get sick. So my advice is for right now, do not open. Now, having said that, I've told my clients that, and some of them just are too eager. Their residents are clamoring to get into the swimming pool. So my backup advice, remember, advice one is don't reopen. Maybe not until June, July. Once the federal public health officials let us know that it's basically safe for most everybody, then I would drop them. But if you're going to reopen before then, my recommendations to you would be to do so with all the precautions. And that's going to be a list of several things. First of all, require masks. Second of all, require social distancing. Next, post signs warning people about the risk of COVID and admonishing to follow them to follow safety precautions. Mandatory temperature checks at entry and denial of entry to anyone who has a temperature of over 100 degrees. And routine intense cleaning to make sure that there are no surface-borne viruses. So either don't do it or do it as carefully as you can. But I know everybody's eager to get to the swimming pool. I checked the water in mine a couple of days ago, and it's just about warm enough to make it nice to get in there. So I can understand. But if you've got a community swimming pool, I'd recommend you consider those precautions. So I think I've said enough. I know Mr. Cagle has his own opinions about this. We're both board certified in property owners association law. We just see things differently. So Mr. Cagle is a lawyer I know and respect, and I'll be glad to turn it over to him.
Thanks, Tom. And as Tom said, lawyers can have differing opinions, and this is one of those issues that I think are unique. How do you operate your common areas in response to an unprecedented, 100-year pandemic? And I'll just share with you sort of my thoughts and opinions and approach to it and what I've talked to clients about. One is we all went through this last year, right? Last year when the pandemic was going on, and summer started and we had the issue with pools and what do we do? And we had the state, the shelter in place orders, y'all might recall. both at the state and local levels. And so my advice is, if there's any state or local executive orders, health authority orders, ordinance issued by the county or municipality, you got to comply with it. So if there are social distancing requirements, mask requirements, checking temperatures, anything like that you've got to do, occupancy limitations, you got to comply with those. And if you can't comply with those, I agree with Tom. If you can't comply with those orders and ordinances, then you should close down the pool. But let's assume for a second that there are no occupancy limitations. Let's assume that there are no binding required social distancing. There's no mask wearing, which is pretty much the current state of Texas right now. That should you as an organization continue to keep your amenities closed as suggested or recommended by Tom, or if you're going to open them, continue to impose the social distancing, mask wearing, occupancy limitations, and checking people for symptoms of COVID, right? Temperatures and that sort of stuff. My general thoughts is no, I don't think you should, for a couple of reasons, and I want to explain why. One, property owners associations are not really set up to be public health authorities and to enforce public health authority rules. That's really not the role of a property owners association. You don't have the same tools as the government to enforce those types of restrictions, and so it can be difficult. Establishing those rules requires you to have meetings, record them in the public record, and then it's going to be expensive and burdensome to keep up with. You've got to have monitors down there. If you're going to adopt the rules, you better enforce them. So you're going to have people down there. You're likely to have to field a ton of complaints when somebody says some other person got too close to them or somebody wasn't wearing a mask. How are you going to enforce it? Are you going to have 209 hearings to suspend them from use of the swimming pool? Are you going to have hearings because you're fining people? Like, how are you going to go about doing that? It becomes a really administratively burdensome job. It's going to add financial pressure to the association to do with it. And at the end of the day, this is what I've asked myself, which is this. Once you take on that responsibility, once you voluntarily assume something that you're not required to do, because if it's not required by state or local law, you're not required to do any of these things. Once you take on this activity, you now have assumed a duty to do so in a non-negligent way. So in some ways, you may be creating some potential liability if you are negligent in the manner in which you clean, or you're negligent in monitoring the enforcement of social distancing or mask wearing, or you were negligent in not screening people who had symptoms. I think the better approach is to do this. And this is what I've advised my clients. Post a big sign, and this is what it should say. We recommend that you comply with all recommendations from the CDC and social distancing and mask wearing, but we are not going to engage in extraordinary or additional cleaning of these facilities. There will be no attempt to sanitize them. We will not enforce any social distancing requirements. We won't screen people for symptoms. We're not going to require masks. If you are immunocompromised or otherwise concerned about catching COVID-19, don't use the swimming pool. And by voluntarily accessing and using the swimming pool, you assume all risks associated with that, including contacting or getting COVID-19. The thought about it is this: everybody has agency here. As long as we give them informed or risk, right? Which is we're not creating a clean environment or a sanitized environment. Everybody gets to make a voluntary decision as to their perceived risk and the benefits. If they think that they want to use the swimming pool, perhaps they've gotten their vaccine shots. Perhaps they're young and don't believe that it poses a significant risk. Then they get to choose to. If there are people who decide, well, you know what, I'm sort of in that elderly category, I have a much higher risk of severe reaction, I'm going to choose not to use it, that's okay too. The reality also is we cannot guarantee, even if you do all of the social distancing, cleaning, all that stuff, there may be people who are asymptomatic and they'll still get it, right? You cannot create a safe environment where they're not going to catch it. That just isn't going to happen. It's an invisible thing. There's just no way to do it. The other part is, what's the risk? There is no way for somebody to prove where they got exposed to COVID-19. So is there a potential somebody could file a lawsuit? Yes. And that potential exists whether you're enforcing social distancing and mask wearing or whether you don't. That risk exists. What's the risk of liability? I would say it's extremely low. And the reason for that is the plaintiff has the burden to prove that you negligently did something that resulted in a harm. So they're going to have to prove that you knew there was somebody there and that it created a risk, or it created a risk of danger, and that as a result they caught it there. But how do they prove that's where they got COVID-19? It's impossible. I'm not saying there won't potentially be lawsuits, but I don't know how a party prevails on it. So I'm not as concerned about the potential liability of people catching COVID, if that's what you're concerned about. I'm not concerned about that. And I don't believe that in implementing all of these social distancing, mask wearing, restrictions and enforcing those is going to prevent a lawsuit either. I think there's still some risks there. I also think that if you close down your pools for a second summer, you may have a riot in your community. Last summer, I can't even tell you how many boards called me because they were getting threatened with lawsuits by their owners, even then, right? Even in the face of state and local ordinances and executive orders requiring pools to impose the limitations and all these other things, we still had owners threatening lawsuits. You've got the state of Texas having lifted all those things, and if you close it again, you may have a mini riot on your hands. I'm just telling you, that's what my sense of it is. Your owners are also going to point out that everything else is open and that they're able to go things. You're going to have owners who some are vaccinated, and they're going to object to these requirements. So at the end of the day, what I would tell you is, I think trying to enforce these types of health authority type rules, which you're not really set up to do, is problematic in the enforcement. I think you're going to assume a duty to do it in a non-negligent way. I don't know that it's going to prevent, I think it's still, you have the potential of lawsuits being filed. I think the better approach is just to allow people to make their own informed decisions as to their risk exposure. And that if people want to go down and use it and you've made them aware, you're not creating a sanitized environment for them, I think that goes a long way. I also don't think it's considered a premises liability. Premises liability really applies to conditions of the property. These aren't property conditions. COVID-19 is not a premises liability issue, in my opinion, because you can't know it's spread from person to person. That's not a premises issue. That's a people issue, and so I don't see it where you have to reduce or eliminate the risk. I think this is more of just sort of a normal negligence thing where you say, look, there's a potential that there might be people with COVID there. And if you're going to swim, you know that you're assuming that risk. So that's kind of my approach to it. Much different approach. And to be 100% candid, I appreciate Tom Newton's approach. Tom's a good lawyer and I respect him. I just don't see this as an issue where I would recommend my clients shut down their pools. And I've also don't recommend that they, adopt all of these standards, especially where the state of Texas has eliminated them.
Greg, there's a couple of questions. The first would be, it came to the chat. You read off some potential wording for signage that communities could use. There's about 2 or 3 of those asking if you could spell that out for everyone so they can write that and use, I guess, in their facilities. It was you read it off so perfectly.
Yeah, so I've got it prepared. It's something that I provide to clients. So it's kind of a work product issue. Happy to, if anybody wants to, won't cost very much, but happy to provide it. But I also want to look at their individual governing documents to see specifically what the items are. So even though it may generally apply to all, there may be some nuances where I'll tweak it for each community. But here's the gist of it. Give them informed consent, right? Warn them of the risks. And what you're warning them of is, look, we're not creating a sanitized environment. We're not gonna engage in additional or extraordinary cleaning of these facilities. Make it clear to them. We're not going to enforce any social distancing requirements, mask wearing requirements, occupancy limitations. We're not going to enforce those. So that way they're not calling you and say, hey, so-and-so got too close to me. We're not going to enforce those. And then tell them if they're immunocompromised or if they have any concerns whatsoever about catching COVID-19, then they should not use these facilities, right? You're going to tell them, if you have any concern, don't use it. And if you do use it, you're assuming all the risks associated with that, including, being exposed to the COVID-19 virus. That way they can make an informed decision. And if somebody says, well, hey, I caught COVID-19 down there, when you say, yeah, we told you that might happen. But I caught it. Yeah. Well, you didn't clean. Yeah, we told you we weren't going to. I mean, that's what you're trying to do there. Making an informed risk decision and an assumption of that risk.
Thank you. One other question is, if there are no county city restrictions regarding COVID, what protections does an HOA have from suits?
Say that one more time, Jesus.
If there are no county, city restrictions regarding COVID, what protections does an HOA have from lawsuits?
Well, they don't. I think Tom did a fantastic job of explaining, the charitable organizations immunity statutes. But anybody can file a lawsuit. Now, whether they prevail or not is a different issue, but anybody can file a lawsuit because there's not somebody there at the courthouse who screens them and says, yes, this is a permissible lawsuit or not. So the potential for a lawsuit is there. There are things you can do as far as risk mitigation. One form of risk mitigation is close your pools, right? I mean, that's one that, if you don't want to get sued for anything related to the pools, close your pools. That's one thing Tom raised. In fact, I've had people say to me, how do we reduce liability of swimming pools? And I said, and what I'll tell them is any hole in the ground filled with water carries some degree of risk, right, of liability. You can't own a swimming pool and allow people to use it with zero risk of liability. So just, there's an assumption, there's some risk assigned with swimming pools because people can drown. So catching COVID-19 is one risk, drowning is another, but there's risks assumed with swimming pools that every association has to look at and say, are the benefits of having a swimming pool outweigh the risks, the potential risks of liability, because there are risks. If you want zero liability, fill it in. Don't have a swimming pool, right? So it doesn't matter what amenities you have, there's always risks that people could get hurt. There's always risks that people could catch COVID-19. And so you can't eliminate that risk. But insurance is a risk mitigation, right? Having insurance coverage that would cover things. Having the insurance coverages that would trigger the charitable organization's immunity cap for the association is a risk mitigation strategy. Requiring people to sign waivers and releases is another form. And in fact, with some of the swimming pools, not only do we post signs, but we've added that language that I described to the swimming pool waivers and releases that they make owners sign. Now, I've been asked, what's better, the waiver, having waivers with that language or the signs? The reality is the only people who sign the waivers are the owners who get the fobs, but it's not going to, it isn't signed by guests that they bring in, and it isn't signed by, minors. And so it serves one role, is that you might be able to impose some indemnity obligations in the waiver release agreement, but it's not going to apply to all the people who are using the swimming pool who were let in by the owner who signed it. So having the signs, at the entrance to the swimming pool means that anybody who presumably can read is going to see that sign, and you're going to say, yes, we gave you warnings about it. So, if you really want to reduce as much as possible with that, you could do signs and waivers. So that's another strategy. So I think that's sort of the gamut, but at the end of the day, there's always going to be some risk that there might be a lawsuit, no matter what you do.
Let's see here, Tom. I'm going to back up a second and ask a question that came in while you were speaking. This is pretty straightforward. Could you explain why a condo common area such as a pool or a park is considered public?
It's not public.
It's not.
It's not.
So any, common areas owned by a property owners association for subdivision development is considered private property for the exclusive use of the owners and their guests. It's not considered public property. It's not considered what we call a public accommodation under the Americans with Disabilities Act. Same thing for condominiums. And in fact, the common element swimming pools are owned by all the unit owners in common. It's not even owned by the condo association. But again, it is treated as private property. It's not considered part of it's not considered a public accommodation under the Americans with Disabilities Act. It's not really considered public property.
Yeah, that's correct.
Before we get on to Mark, and Tom, I'll certainly let you add anything to it. Does a pool waiver protect the association from gross negligence?
Well, I'll tell you what my thought is. A waiver is basically a contract where the person who signs the waiver gives up their right to make a claim for damages. And the problem I have with a waiver is if you don't give them anything, then there's a pretty good argument that there's no consideration to support that waiver, and it may not be legally valid. It may, however, provide liability protection in the form that people may consider it to be valid and therefore not assert claims they would have otherwise. A waiver, if properly done and supported by consideration, can waive even, I believe, claims for gross negligence. But in the absence of some independent consideration to support it, owners have easement rights to use the pool, right? If you're going to open it up, then it's kind of hard to condition that. I mean, you can make reasonable rules and regulations governing use of the common area for sure. But it's not something that I think is going to save the day if you go to court. Greg may have a different opinion.
I totally agree with Tom. You can put it in there and hope that it might stand up to scrutiny and challenge in a lawsuit. You can also not only, in a waiver release agreement, what we typically put in there is, that the person signing this is agreed to waiving the claims, agreeing not to sue. But then we'll also say they agree to indemnify the association if the association is sued by anybody else who accesses the pool by or is allowed access to the pool by this particular owner. So if the owner brings guests in, right, the guests are not going to be, they haven't signed a waiver agreement. Guests file a lawsuit, and potentially you go to the owner and say, well, hey, you know, we've got an indemnity obligation. You need to pay for the association's attorney's fees to defend this. Now, whether they have the money to pay for that, and whether whether there's sufficient consideration to support that agreement is an issue. And you know, that's always going to be an issue with waiver agreements, but it gives you something, but it may not carry the day. And I agree with Tom's thoughts on that.
And just one thing to add on to that is indemnity agreements are very hard to write the right way. You have to comply with what's known as the fair notice test under the Dresser case, which means it has to be clear and conspicuous. And you have to expressly state that the party indemnifying the other party is indemnifying them, the indemnified party, for their own negligence. So if you don't have an indemnity agreement drafted by a lawyer that knows what they're doing, it'll be, if found invalid just for failure to comply with that test.
Somebody just posted something on the chat that says under general liability, there's also a newly added exclusion for communicable diseases in most, if not all, insurance company policies. How would the insurance protect the POA under those circumstances? Well, if there's a properly drafted exclusion, well, then it means the insurance company is not going to cover it, which means, you know, the association would be self-insuring it and essentially covering its own costs to defend. I don't think that changes anything that I've talked about, which is, regardless of whether you implement all these strategies, you know, the social distancing, the mask wearing, all that sort of stuff, may not, you know, if somebody catches the disease down there at your pool and they decide to file a lawsuit, you're going to have the same issue, whether you enforce those sort of rules or whether you tell them you're not and you tell them it's an assumption of risk. I think I just don't think it has that much of effect. Will it reduce the number of cases where somebody catches COVID? Possibly, but who knows? Because nobody can tell you where they caught COVID. Nobody can tell you. You can have people who are asymptomatic. I mean, there's no way to know where somebody caught COVID, period. Or at least I'm not aware of any ability to prove that. So, you know, you could enforce all these rules. Somebody catches COVID at the local grocery store, but they think they got it at the pool because somebody wasn't wearing a mask and was standing right next to them, even though you had rules that said they shouldn't.
All right. I think it was a lot of good legal discussion, great presentation. So we're going to switch gears right now. And Mark, I think you're still on the call. If you can unmute yourself, and then Mark's going to go over a little bit about who he is, who he's with, and then take it away on some experiences he's seeing every day with community associations.
Absolutely. I appreciate it, Jesus. I'm with Seven Wells Pool Management. We've been managing community pools for 16 years in the San Antonio area and surrounding area as well. And have dealt extensively with all of these questions throughout the summer, last summer, and even into this summer, trying to understand, you know, what it means that there are no more restrictions and giving our boards as much advice as we can. I think meaningfully, I can probably address two things: what practically ordinary care possibly means. And Tom and Greg, please step in if I've overstepped my legal bounds, because I know nothing about all of these legal implications of how this is applied. And then also the financial pressure that it puts on communities that choose to have different restrictions. So first of all, ordinary care. You know, and I guess what I want to address here is some of what Greg was talking about with everybody who comes to a pool, there is an assumption of risk, and there's signage everywhere that's required by state code to address the assumption of risk. You know, the no lifeguard on duty. Even if you don't open your pool, other than when you have a lifeguard present, you are still required to have those no lifeguard on duty signs, which again, every user of that pool is assuming risk, and that's that signage basically telling them you are assuming risk when you walk into this facility. And so if you've have followed those Texas codes for communicating properly what a community should be communicating to the users of that pool, to me, that's ordinary care. You know, if you're following the legal counsel, you know, and then you are also following what we have asked and what we have noticed in applying that administrative code to pools. In the off season, we give suggestions to every community. You know, we have these safety items that should be addressed. We have faded signs. We have, you know, faded or worn out shepherd's hooks or life rings. All of those items that are poolside that, again, you're providing ordinary care to the users of that pool, by providing those things that are required by Texas code. And so, I mean, that would be my first point, is I believe that going with what Greg said, that when you have communicated properly to everybody entering that pool that there is an assumption of risk, you know, I can't say whether or not it's going to release you from liability, but at least you've done due diligence to not be negligent in that area. And so, and then the second part, financial pressure, if the community does decide that they need to somehow restrict access, which is not necessary currently under any county restrictions, the Texas state release of restrictions supersedes any locality restrictions when it comes to private places and private ownership. My understanding is any private ownership, such as a business, they get to decide on their own whether or not they're going to enforce restrictions. You know, financial pressure, I can speak to, you know, that financial pressure that would be put on the association if they do not have staff currently, or if they do have staff and there may be additional staff that's required to enforce some of those restrictions. There's only so much you can expect out of lifeguards that are on site, or even a pool attendant. There's only so much you can expect from them, in addition to their regular duties of regulating entry, as well as ensuring that the facility is properly sanitized. And enforcement, you know, it's difficult if you walk into HEB. This is what I typically tell my boards. If you walk into HEB, you typically have a security guard there, or somebody in authority there, one of the managers that is enforcing mask requirements. I guess not so much now, it used to be. But you'd have that situation at a community pool because it's outside. People aren't used to always wearing a mask outside. And so that type of enforcement would be necessary. And you have to decide what kind of person is going to be required if you have that if you have that restriction, what kind of person is going to be required to meaningfully enforce those restrictions. So, I mean, those are some of the things that I could address if there's specific questions. I mean, a lot of y'all have already dealt with those over the past year. There's been very few pools over the past year that have actually been closed. The vast majority of our pools were open this past summer. And, you know, I want to say 100% of them are planning on opening this year. Maybe a delayed opening in the late May, similar to what Tom had suggested, you know, waiting a little bit until there's more vaccinations out there, there's more direction from the federal government. but I think most of my communities are following the Texas expectations.
Mark, let me ask you a question. When this all began, the pandemic, a lot of communities, there's a lot of discussion about, COVID being on surfaces and how long it stayed on metal versus wood and things like that.
Right.
A lot of communities, they pulled their chairs and tables and put them in storage. Are you seeing communities do that now? Are they still spacing them out? Or is it, still a best practice to, some communities had residents bring their own lawn chairs.
Right.
And what are you seeing right now out there?
Yeah, and most definitely, we're seeing that most communities are saying put them out at 100%. So really no restrictions whatsoever. And you'll have to give me just a second. I need to plug in this computer, otherwise you'll lose me. Give me just a second, but I can hear. So go ahead if there's any question.
Yeah, you're there. Sorry about that. Yeah, and Mark, can you speak to, again, I'm going back to a year, kind of where we are. It's been a year now, a little over a year. I guess we know chlorine kills, the virus. Are you still seeing, or are you, putting in more chemicals than you should be, which would obviously drive up costs for community associations? Or are you seeing that kind of going back to normal the way it was pre-COVID?
We personally, we keep our chlorine levels at the high end of acceptable range anyway. We just find that that's the best means to keep the pool sanitary the entire, the most consideration obviously is weekends, when you have, sometimes some of these communities have 100, 200, 500 people in that pool over the course of a Saturday. And so we tend to keep our chlorine levels high so they never dip below 3 parts per million. And definitely in down times such as overnight, they spike to 7 parts per million when acceptable is 1 to 8. And so we didn't necessarily raise the levels. We've always kept them there. But I can tell you this, that my understanding, at least the science early on last summer, was that this virus is not very vibrant under any kind of chlorine type environment, or chlorine situation or chlorine introduction. So, or any kind of sanitary or any kind of disinfectant. Most disinfectants will kill this virus.
One question we had come through, do you have adequate staffing for pool monitors, or is there a shortage? I know last year there was a massive shortage or a speed bump with lifeguards. And some pools could open, some couldn't. There was obviously the scare of how you take them through training so that they can take care of the residents when needed. What's that situation looking like?
I think we're seeing, I think we're going to see more of a shortage this year. We had, at least in my personal experience, we actually had quite a few applicants because, we're drawing from the same pool as a lot of restaurants and a lot of other recreational facilities that were closed. The community pool was almost the only recreational facility that was open last year. And so this year, things like Fiesta Texas, SeaWorld, most restaurants, a lot of those facilities and businesses will be open this year. And so I think you're going to see more of a shortage. It's going to be difficult. We were able to pull in a handful of communities that at the last minute decided they want to open with monitors present. This year, that's going to be very difficult. So.
And I know you're dealing with city and county inspectors nonstop. Maybe not necessarily COVID related, but are right now, are they honing in on something, whether it's gates or COVID related, locks, pool decks? Is there any one thing in the past several months that or they just kind of stick with the routine as scheduled?
You know what? Most city inspections happen during the summer months, and I don't think I saw one city inspection last summer. And I don't know if they just suspended those inspections due to concerns about their own staff being exposed. That's my assumption. I didn't see any physical inspections of facilities. So, I mean, I can speak before that 2019, but really not more recently what they'd be looking for.
At this point, if anybody has a question, feel free to unmute yourself and ask either Tom, Greg, or Mark.
I see Norlando talked about the water fountains, which is probably the most, I would say, and good question, because I think that is likely the most at-risk area is a water fountain. Because if you have, especially among children, you had 2 children that step up to that water fountain back to back, that would, I would think that would be the highest risk area.
There was a question that came in on the chat about whether a condo is required to have a landline at the pool. And I believe a phone at the swimming pool is required by the administrative code.
That is correct. Doesn't have to be a landline. It can be a call box of some type as well.
They do need a phone though, of some kind.
Yes, sir. Great question, Lewis. You need a good management company. I know some of my managers are on here. He asked about the pollen currently in the pools, and it is a mess. It's a lot worse this year. Be patient with your pool management company. Number one, pools are being used at a rate I haven't seen ever in 16 years because people, they've been told they need to stay inside, and rightfully so. They need to be careful now that a lot more people are vaccinated and we understand more about COVID. More and more people are at pools than ever before at a time when they historically are not used very often. And the lack of rain this spring has made pollen even worse. And so I'm seeing a lot of every one of my complaints, every single one of them has been from pools with large oak trees around them. We don't have any complaints at any other pool. And so it's just a time that we've got to get through. And that should be within the next couple of weeks. Leaf season was very fast this year because of the freeze. So.
I've got a question for both Greg and Tom. And I know what Tom's going to say, but I'm going to open it to him as well. Anyway, we have a pool, community pool, and a clubhouse. Last year, we opened the pool with restrictions. No, we didn't put out our furniture. We put out or made individuals bring their own if they wanted it. And we did not open the clubhouse at all except for the bathrooms, which were accessible from the pool. This year, we plan to open the pool, again, perhaps with some restrictions, but the question is, do we want to open the clubhouse at all for rental?
Well, you're right, Art. You know what I'm going to say. I think it's a little premature. I'd wait a couple months. You should be able to do it fine. By the time summer gets here, I just wouldn't do it right now. But if you do, then of course, my backup advice is do so as safely as you can with all the things we talked about. Great.
Art, I would just tell you, I think if the board wants to open it, that's a decision they need to make. I mean, they're certainly entitled to keep it closed, but if they want to open it, post a sign. Warn them we're not going to engage in extraordinary cleaning or other, precautions, and you use it at your own risk. I think that we're at a point that if there's no state laws requiring anything, I'm not advising associations to take on that duty, because then you've got to do so in a non-negligent way. I don't think you're really set up to do it. I think it's a financial and administrative burden to do so. And I think, people are getting vaccinated, and let them make their own risk assessment. We don't need to make that for them. Let them make that own risk assessment, but make sure it's an informed risk decision by warning them.
Well, I am on our board, and so I'll be voting as well. But the thing that I see, you mentioned, Greg, about an uprising if you kept the pool closed. I think that definitely we have to open the pool, but I'm leaning not to open the clubhouse for rental, mainly because when we have parties there, we have a maximum fire restriction of 75, but we frequently have 50, 60 people in the clubhouse. It's not that big. That's close quarters.
Yeah, and that may not be a common amenity. That's just something that people have access to rent for, for private events. And that may be something you look at and say, we keep it closed, but we'll allow out, the common amenities, basketball courts, playgrounds, those sort of things, for people to use. The cities are open. I drive around Austin, I see city swimming pools open, see city playgrounds open. You're going to find it tougher to keep those closed and justify that to your members, I think.
Thank you.
All right, anybody have any last questions they would like to ask before we have our sponsors say a little something about their companies? Any last questions? All right, well then, Sabina, would you like to talk to us about Alliance Association Bank?
Absolutely, thank you, I appreciate it. Hi everyone, my name is Sabina Holton and I'm a Senior Vice President with Alliance Association Bank. And I represent San Antonio, Houston, and Austin area. Alliance Association Bank is a national division of Western Alliance Bank Corporation. We do have a New York Stock Exchange symbol, which is WAL. We are a very strong financial institution with 36 billion in assets. My background is actually in association management industry. I did it for 21 years prior to changing careers to the HOA specialized banking. I've been with the bank going on 10 years now. So I've been out of the business as far as the HOA management side for about 14 because I actually started with another bank prior. But anyway, our division, we provide specialized banking to our management companies and association clients, including lockbox services, remote scanners, and integrations with many of our software providers. We're also very excited to have developed our own homeowner e-payment and management portals. We also provide loans for communities in the need of capital projects. I would love to do a demo for you if you would invite me to do so. We've been around for a long time and we have very good proven track record. So please feel free to reach out to me if you need anything. And I do appreciate CAI for giving me a few minutes of your time. Thank you.
Thank you, Sabina. All right, and we've got Ed Puente with Craftsman Commercial Playgrounds and Water Parks. Ed?
Yes, appreciate you guys letting me stick around and listen to this. A lot of good information. If I haven't reached out to you yet, Craftsman's Commercial Playgrounds and Water Parks. I represent them in the San Antonio, Austin, matter of fact, all the way up into the El Paso area. We provide playgrounds, dog park equipment, park furnishings. So we do tables, benches, trash bins, grills, bike racks. We like to say that we're the one-stop shop. As I said, playgrounds, dog parks, we do shade structures, we do outdoor fitness equipment. We have interactive playground equipment that's new that we carry as well. We also do fall surfacing. This is a great topic that was talked about. And with that being said, we built over 350 splash parks across Texas. One of the things that kept coming to my mind as y'all were speaking was we also carry hand sanitizers, which has just been exploding with everybody calling and asking for these hand sanitizer stations around playgrounds, around splash parks. With that being said, I hope you guys give me a call or shoot me an email if there's anything that we can do. I've worked with, looking at some of the names out there, with a few out there. And we've got some really, really cool new playground equipment that's out there as well called Lab Set that I'd love to show you guys at some time if you want to shoot me an email. But again, thank you guys for letting me speak. And if we could do anything to help you guys out, please give me a call.
Thank you, Ed. All right, Jesus, let's draw some names. Give out some gift cards.
All right, let's give some money away. Let's see. First up, let me pull up my spreadsheet. Judy Parker with Associa Hill Country. Looking here. Let's see. Judy, are you on the call? I believe so.
Must be present to win.
Must be present. President's call. All right. Once, twice, gone. Next up, Norlando Williams, Bridgewood Association, Rail Manage.
Thank you. Thank you.
Yay, Orlando.
Orlando here. He's here. Okay, good. Awesome.
Yeah, he's here.
Congratulations. Mark it slide now. Sarah Huff, CCMC.
Yay, Sarah.
All right, I see Sarah there.
She was on. Let's see. Sarah, you still here?
There she is. All right, two more. Courtney Pickett also with CCMC. I don't believe she's.
Courtney. Nope, don't see her.
Nope. Matthew Hallbrook with Laurel Mountain Ranch Homeowners Association, Diamond Association Management. Matthew, are you on the call? All right.
Nope.
Looking better and better for some of you. Juan Garcia, Spectrum Association Management. And stick around.
Well,
Next up,
right.
Luana Johnson, Wellwood Management Group.
cool.
There she is. All right. Congrats. And so we've got one more to give. These are $50 each. Here we go. Peggy Spoor, First Service Residential. I thought I saw Peggy on the call earlier.
I see a Peggy. I don't know if it's her.
Let's see.
Nope.
No, Peggy. Okay. This must be a different one. Here's the next one is Deanna Rizzo with Alamo Management Group. Deanna not on the call.
Nope.
Going through my list. Karen Guzman with Avid Property Management.
There she is. I see her right there.
She's there. Alrighty. Congratulations, Karen.
All right, everyone. Well, congrats to those that got a gift card. And before we part ways, just wanted to extend a thank you to Greg and to Tom and to Mark for spending your time with us this morning. This is really, really informative. I'm sure all of our members really appreciated the time and the information. So thank you. Feel free to come back anytime and speak to our membership. And with that, I will just say, everyone have a wonderful rest of your week. Please stay tuned for some information on upcoming in-person events. So do watch your email because we are going to be planning some in-person events, maybe some hybrid events. And so be looking for those. And otherwise, have a great week. Thanks for joining us, and we will talk to you later.